geographical point of view and global as well from let's say applications point of view, as it is a combination of flavor and fragrance activities, and both are falling under the scope of Nagoya. And just to say that today we don't see ourselves like, you know, only reporting or trying to understand what's going up. And this would take us much time because we are now having more than 200 pieces of regulations. But we are seeing ourselves more as a solution provider, and we would like to be recognized as a solution provider. Solution provider by sharing these and preparing these webinars. The webinar that we gave last year on Brazil for flavor and for fragrance as well. The guidance, the document that could really help companies to in their discussion and their organization, but as well more practically trying to be on the field. And we have started recently a project that would that is going to help industry in South Africa, and this project will be briefly presented by Michael. It's the Bushu project. So our mission, so really the vision is to be a solution provider. The mission is to raise awareness, okay, and help the members to understand and try to facilitate the works for the companies. We have to monitor the national regulatory developments, which is quite big. So there is a must-have to have priorities, and we have selected priority countries that I'm reading on my sheet. For the time being, we are focusing our energy on Brazil, South Africa, India, and the European Union. So that's really the national specificities that we are discussing in details in the task force. We have a couple of key topics as well that we are monitoring and following, which is the definition of utilization that we are going to talk a little bit more about, which is still lacking clarity. Some consideration on derivatives, whether they are out of scope or in scope, depending on how we use it. And as well the digital sequence information. And all those topics are going to be detailed a little bit later. One aspect that is very important is our partnership with the regional association. You can see from this webinar that we already have 2 regions, Brazil and South Africa, and partnership as well with some well-known stakeholders like UEBT, NGs, that are helping us in our Bushu project, by the way. Next slide. Just to conclude, I wanted to present you the team. So as you can see, that's quite a big team. So we do have many flavor and fragrance companies. We do have many associations, upstream, regional, national associations, but as well some customers. Delegates from companies are coming from regulatory affairs, but as well from sustainability, sourcing, R&D, and compliance. And this diversity shows the sort of global ownership of the biodiversity questions. So I wanted to take this opportunity as well to thank the group, to thank each person for supporting the activity. And I have to say that despite the fact that the task force is big and that we are coming from, different culture, different languages, different backgrounds, and the topic of Nagoya and biodiversity is quite complex, sometimes unclear, the progress and the level of discussion is really good. So thank you very much for this. And you have the achievement and the deliverable with the guidance. By this, I would like to close the introduction, and I believe that we can. The floor is now for Maxime to present the Nagoya protocol.
Thank you, Jocelyne. Hello, everyone. So My connection is not so good, so I'm gonna try with the camera open, but if something failed, just inform me and I'll turn it off. So welcome everybody. Before we get into the substance of the guidance document, let me briefly give you some background element on the protocol in itself. You can go on next slide, Nicole, thank you. So the Nagoya Protocol is actually the third pillar of the Convention on Biological Diversity. So the convention entered into force in 1993, and it was basically the moment where the world started recognizing the high importance of biodiversity for us now and for the future generations. So with three main objectives, three main pillars. So the conservation of biological diversity, the sustainable use of its component then, and finally, the fair and equitable sharing of the benefits that would arise from the utilization of a genetic resource, so a genetic material of actual or potential value. So the Nagoya Protocol implements this last pillar with the objective to ensure that these benefits are fairly shared between the user and the provider side. And in the same time, it also contributes to the conservation of these genetic resources because it gives a value to biodiversity and to the ecosystems. So we have the protocol, and then of course, we have the countries who need to transpose and to implement the rules and the principle at the national level through their own legislation to become a party. So I'll come back on this in a few minutes, but yeah, what are we talking about exactly? You can go on next slide, thank you. So what is the material scope of the protocol? So it can apply to genetic resources, to derivatives, and or to traditional knowledge associated to this resource. So here I don't intend to go into the detail of these terms, for a better understanding of these concepts, but also to see the remaining gray zones around these concepts, because there remain some gray zones. I really invite you to consult the guidance in itself. And on top, in the national legislation implementing the protocol, sometimes it may refer to different terminologies like genetic heritage, biological resources, etc. So it should be always compared to the terms of the protocol, but on a case-by-case basis. But to be brief, let's say the genetic resource, it means genetic material of actual or potential value from any plants, any animal, any microbial or other origin, and which contain functional units of heredity, so DNA or RNA, and the derivatives, so the biochemical compounds resulting from a genetic expression or the metabolism of these resources. And finally, the concept of associated traditional knowledge. So there is no proper definition in the protocol, but by common understanding, we could say that it refers to all the knowledge, all the innovation, all the practices relevant for the conservation and the sustainable use of biodiversity. So for example, all the agricultural practices that have been developed and experienced over the decades and over the centuries to have what we have today, basically. So now, this access and benefit sharing system, how does it work? Next slide, please. So here again, very basic explanation. The specific situation of access and utilization will always differ from one time to another, depending on a lot of factors like where you access the resource, when, how, etc., etc. So here it's just to explain the concept. So first of all, just to remind that in most of the case, when it comes to normal trade or existing use of material, there is no obligation. Similarly, if you access and use a material or a genetic resource from a country that has not implemented any ABS rules, again, no obligation, this is free to use. But this being said, you can always set some provision on a voluntary basis if you would like to say to do so, but nothing mandatory. And in other case, so the blue, the purple and the orange part of the slide, very concretely, the objective is to formalize a relation between the user, so us, the industry, and the provider country to be sure that a part of the benefits that arise from the sales of a new product developed from the access to a specific resource will be shared with this provider country. So it can be monetary or non-monetary benefits. Non-monetary, it could be collaboration, cooperation in the field of scientific researches or programs, in the field of education, for example. It could be a lot of things. And in this purple situation, the user is always subject to all legal requirements. So, okay, I think everybody still hear me, I hope so. So I was saying that the user is always subject to all requirements contained in the local legislation of the provider country, like establishing what we call a PIC, so a prior informed consent, or a MAT, for example, a mutually agreed terms. And we can go on the next slide, please, to continue a bit on this PIC and this MAT. So basically, these are both the two primary tools for the provider country to authorize the access to the genetic resources and then to control the use of the resource and then establish an effective benefit sharing mechanism. So the objective of the PIC is really to allow the concerned people within the provider country, so the people who hold the traditional knowledge, but also, of course, the authorities of the country to be informed about the potential use of their resource in order to make a decision on granting or not the access to this resource to the potential user. And then if the access is granted, then you have to establish mutually agreed terms, so the MAT, which is a contractual agreement between the user and the provider, where you'll find some specific provisions, specific condition for the fair and equitable sharing of the benefits, but it may also contain other conditions regarding the application and the commercialization of a product, for example. And finally, just to highlight that it's the obligation of the parties of the protocol to take any effective measure, any necessary measure to provide a legal certainty. So then to issue to users a permit or something equivalent as an evidence of granting this PIC and establishing this MAT. And now, talking about the parties of the Nagoya Protocol, we can go on my last slide. So there were 123 parties end of April, and I haven't checked today, but I think that the number is still accurate. You can find a lot of relevant information about these parties and the way they have implemented the protocol. And you can find this information on the Access and Benefit Sharing Clearinghouse website. So you have the address in the bottom right of the green box. Sorry, it's very small actually. So it's absch.cbd.int. You will have anyway the PowerPoint afterwards, so this is not a problem. So as already explained, in order for the protocol to be effectively implemented, parties need to implement and to transpose its principle within their own legislation. So the problem is that we have seen arising a lot of very different way of doing this implementation from the country. So different type of measures at different scales, at different levels, sometimes with different kinds of ambitions. And for example, some countries have even established ABS rules and provision without being party of the protocol, like in Brazil, for example, and I'm sure Eugenia will explain this. So at the end, we have this very complex framework, this lasagna of legislation in which it's very difficult to navigate. And at some point, as Jocelyne said, it was really justifying the need for us to make such a guidance for our membership. And here I'll give the floor to Matthias, who will pursue on the motivation of IFRA and IOFI to develop this document and on the structure of the guidance. Thank you very much.
Okay, thank you, Maxime. Just before Matthias comes in, I just want to, this is David O'Leary, and I just want to repeat my presentation from the beginning, my introduction. As I understand, some of you couldn't hear it because of the bandwidth issues. We all had our cameras on, so that's a lesson for us. It's just to say, if you have questions, we're very happy to receive them and we'll answer them at the end. You just have to type it into the question box as everybody is on mute. Any technical issues, put a message to me in the chat. And also to let you know, the guidance document is available on the webinar platform. If you go to the handouts section, there's a link to that document. So we'll carry on with the presentations with Matthias, then we'll have question and answer session and a quiz. And yes, I'll hand over to Matthias.
Thank you very much, David. So it's now my part. Welcome to everybody on the webinar to talk a little bit why we did this guidance, what was driving us, and how it's structured, how it's built. It's quite a long and complicated document, quite extensive, a lot of information. So we wanted to provide you some guidance through or into the guidance. Next slide. But before to do that, just to re-emphasize that the flavor and fragrance industry, so it's a common project between IFRA and IOFI for the fragrance and flavor industry. We both really strongly support the objectives of the Nagoya Protocol and to help the sharing of benefits of utilization of genetic resources as outlined by Max. And the guidance document, that actually has two main goals. One is to raise further awareness within the membership, which we still feel is necessary, just simply given the complexity and the breadth of the legislation, but also the speed with which it sometimes develops. And then at the same time, we wanted to provide some assistance in helping to go and find the way through the complexity of the framework, trying to understand where to start in building up a system in a company to help being compliant for the cases where that is needed. Next slide. So we have a number of main aims of the document. We want to present, again, as simple as possible, the key content and the requirements of the Nagoya Protocol, which is then in most of the cases inspiring the implementing ABS legislation, plus some of the cases already pointed out by Max, where countries already have such inspired legislation in place without actually being part of the Nagoya Protocol signatory countries. We want to try, or we try as best as we can, to propose a common understanding on the potential impact of these legislations in place on key activities that we have in our industries, the fragrance and the flavor industry. We wanted to point out potential implications it actually has on the business, the way we operate, we build our structures. We should organize ourselves in the companies, and also wherever possible provide some key interpretation and help to best or better understand national legislations that have implemented the protocol. It's quite a complex task because the protocol is the guidance, and then it very much depends on the implementing legislation, how they then define specific elements. The guidance also tries to help develop the company's internal policies and processes that ensure companies are in compliance or can demonstrate their best efforts to be in compliance with the obligations that are coming from the legislations derived from the protocol. As pointed out already by our chair, there is a number of key countries, and it might is subject to change somehow. on which we focus to provide additional information and guidance on the respective legislation. And it's therefore provided in attachments. That allows us to update those documents when there is a need, so we don't need to change the whole document as such. We have defined and we are providing attachments, and then when there is a need, we will update those, or we will provide additional attachments for new countries coming into the scope of being of higher relevance for our industries. Next chart. We see the compliance with the requirements of the Nagoya Protocol as a key element of sustainable and ethical sourcing of natural raw materials. And it has to be understood that non-compliance with the protocol or respective regulation cannot only have significant negative business impact from a financial point of view, but also, and maybe even more, from a reputational point of view. Ensuring compliance is requiring a lot of details and traceability along the supply chain, and raising awareness at all different levels of the supply chain to have a due diligence process in place at all steps, so that you can trace and identify where your raw material comes from and whether or not it does fall under certain requirements, or whether you have to document that you are in compliance with respective elements of national or regional legislation. A bit of a challenge for our supply chain, and those active in the industry know that well, is that it's very complex with a lot of different partners involved, and therefore we really want, with our document, with the guidance, help to provide understanding and ensure good communication with all stakeholders involved and engaged, which is also reflected, as Jocelyne pointed out, in the way our task force is structured. The first chapters of the guidance are taking care of describing the supply chain as we understand it, describe typical sourcing activities, and we are addressing certain elements of processing and synthesizing of raw materials, so that we have a good understanding on how we can present our supply chain and where the touch points are for elements that require compliance with Nagoya Protocol. Next chart. So we have structured the document in a way that you best understand certain key concepts, certain touch words and touch points used, certain terminology that is always coming up when you deal with Nagoya Protocol or related ABS legislation. This is some of those are listed here. We try to help understand what the geographical scope means, the temporal scope, when did regulation come into force, is there a period to which it applies retrospectively, all these elements, the material scope already mentioned, what is actually in scope when it comes to sourcing of materials, what is understood as genetic resource, and specifically also the associated traditional knowledge, personal scope, who is affected and in which way, and how do you organize yourself. And certainly there's also the terminology of utilization. What does it mean in the context of the Nagoya Protocol? And we also try to describe what should or could be understood under research and development, which is a terminology that is permanently raised in the respective legal text. Next slide. The regulatory framework is really very complex, and I think Thomas Delille will come back to that at the end of our presentations, with a lot of intertwining of regulations, international, European, national rules, and we try to explain that complexity as best as we can. As already pointed out, we have focused on some key countries where you will have individual presentations following on some of them following my talk. We have developed this, as already pointed out before, with our Nagoya Protocol Task Force members, and it's again a moment to thank them all for their engagement, and with a lot of support from the national associations that we have around the globe to help us understand the individual specificities of certain regulation. We also maybe want to use this opportunity to point out that we also depend on that our members keep us informed. So the moment you become aware of developing regulation or new elements, we are very thankful if you bring this information to the attention of the task force and the secretariats so that we can define and decide on the necessary actions that may result. Next slide. It needs to be pointed out, and that's part of the problem and part of the motivation for writing the guidance, that there remains some lack of clarity on specific concepts that are raised in the Nagoya Protocol and that eventually are not also then defined in the implementing legislation, or they are defined in different ways and different implementing legislation. And one of these concepts is derivatives. So material that is derived via certain steps from the actual natural raw material, and whether or not this is in scope. We try to describe really as best as possible in our documents a shared understanding of these concepts, but it has to be understood that some of them remain vague and that the members have to be very attentive to those elements when looking at national legislation, when trying to deal with national requirements. But it's also important to keep those touch points in mind when we are becoming aware of legislation that is under development, so that we can ensure potential advocacy steps to achieve sufficient clarity when the legislation sees the light of the day. And it will be up to Thomas to point out specific elements of legal uncertainty at a later moment in time in this webinar. And that actually already brings me to the end of my intervention. Thank you very much, and I hand over to the next speaker.
Hi everyone, Stephanie from Firmenich. Thank you for joining the webinar, and as mentioned by Jocelyne and all the team, we are very happy to really share the outcome of our collaboration. I will focus on the Swiss regulation just to show you an example of a correct practical regulation in terms of the Nagoya Protocol that really tackle the access as well as the benefit sharing and the compliance feature of the Nagoya Protocol. Can you please go next, please? So just as a few highlights on the key timelines. So first, Switzerland ratified the Nagoya Protocol. Then they amended their Federal Act on the Protection of Nature and Cultural Heritage, where they transposed and reflected the notion of the Nagoya Protocol. That act then had been built on with an ordinance dedicated to the Nagoya, where it really explained the access measures as well as the compliance measures that are actually very important for the users. So the users are the one undertaking R&D activity and utilization, and the country where they are undertaking these activities might have compliance measures to ensure that they are respecting national regulation from the provider country, so from where they accessed the genetic resources at the origin. So the Swiss regulation is tackling the notion of access from Switzerland, benefit sharing obligations with Switzerland, as well as a compliance measures when the user is based in Switzerland. The national focal point is the Federal Office of the Environment. You will, while getting the slide, you will get access also to the different links to reach out to the dedicated web page of the focal point. And you have two, today you have two competent authorities for compliance that are listed. One is a Federal Food Safety and Veterinary Office, meaning that when you put on the market a new product that would need a registration under this ministry and all the Federal Office for Public Health, you will need, and they already have measures and forms to fill in to show that you you are compliant with the national regulations where you access the genetic resources. If you really look into the details, the Swiss regulation is quite consistent with the European Union approach, and it's therefore easier for us when we are based in Switzerland to understand and to ensure a certain level of harmonization in the region. Next, please. So tackling the access of genetic resources from Switzerland, actually you don't need to have any prior approval, so meaning you don't need to go through a prior informed consent at the time of you are getting the sample of your genetic resources. But when you go on commercialization, so just before market approval or commercialization, you have to fill in a dedicated form dedicated to access of genetic resources from Switzerland. In that form, so it's really kind of an authorization approach, you will need to fill in several kind of information, and some of them are listed here. So the name and address of the users, the description, the dates, whether or not you have accessed it directly or you used a third party, whether or not you have transferred that genetic resources to another user. So such data would need to be filled in a form. Nowadays, a form is a Word document, quite simply set up with field to be filled in. These records, and you can go next, these records will need to be kept for 10 years. And this follows also the EU regulation that you really need to keep records, and 10 years is usually longer than what you would use or kept for invoice processes or accountability. So it's really 10 years is a big framework, and you really need to keep that to trace all your activities and access. Another point that I really want to highlight here for potential user from Switzerland or accessing from Swiss biodiversity, if you collect in the wild, you have a dedicated clause in this Act for Nature and Protection of the Cultural Heritage, where you should get an authorization from the canton. And this is not linked directly to the Nagoya Protocol. It's for the protection of biodiversity. So it was there before the amendment, but it's even more relevant in the case of the Nagoya Protocol, because therefore now you have compliance measure at the commercialization. So you need to show, when you access from Switzerland, you need to show that if it was a wild collection, that you get that authorization done before, and if it's from another provider country, that you get the necessary permits if applicable. Then can you click please? You still have gray zone. As mentioned earlier, we really tried our best to provide clear guidance and insights. However, you still have the notion of derivatives, the human microbiome, the digital sequence information, as well as the screening approach that are not necessarily featured very precisely in the Swiss regulation. However, they have released some frequently asked question documents that they try to update regularly, and you can have access to them on their page and their websites. What we have as a reassurance is that they really follow the European Commission guidance documentation. So when you or your company is able to follow the European guidance, therefore it will be very easily applied in Switzerland too. So monitoring one aspect will allow us to monitor the second regulation, therefore the one in Switzerland. Next, please. So with regard to benefit sharing, when you access genetic resources from Switzerland, there is no legal obligation with regard to benefit sharing. However, it's clearly set in their frequently asked question and in some non-regulatory documents that they really and strongly encourage voluntary benefit sharing mechanisms and agreements that therefore needs to follow the rules of fair and equitable sharing mechanism. So in a sense, it could be seen as a free access, but actually they really will recognize voluntary measures of benefit sharing. Next, please. So some things that that you saw in Maxime's slide, it's the ABC of ABS. A standing for access, B for benefit sharing, and C for compliance. One new aspect of the Nagoya protocol compared to other international mechanisms is that they really have clear provision around compliance. So how a party or a country reflecting the Nagoya protocol guidelines would try to check compliance, and parties should and have to put in place checkpoints and compliance measure. In Switzerland, this is also clearly set. It's very close to the European approach. So it's before market approval or before commercialization. How it's the same kind of data that you need to record, to keep, and to pass on if you have a certain technology transfer or genetic resources. You need to pass it over to the next user. So how it is checked in terms of compliance. So one aspect that is a tool managed by the ABS clearinghouse is the issuance of an internationally recognized certificate of compliance, IRCC. So if you got such IRCC from the provider country, in Switzerland, you would only need to show that certificate to the authorities when you go through commercialization. If the IRCC is not available because the country is not yet party, because they have not went through this recognized process with the ABS clearinghouse, then you would need to fill a form which contains information about the user, the description of the genetic resources, date of access, what kind of genetic resources you got, and all this different information you see here listed. Again, it's the format of a Word document, a form that you need to fill in and provide to the authorities when you go through whether a market approval, depending on your sector, or a commercialization. Next, please. So you have to show compliance not every time you have a sample in mind. So you need to identify and to do your own legal assessment depending on the national regulation about what is utilization within the national regulation. For the Swiss regulation, it really has the same meaning of the Nagoya protocol. So really looking into research and development, discovery, innovation. As well, you need to, so when you fall under that activity, therefore you would need to show compliance. Another point that you need to assess to understand whether you have or not to show compliance is whether or not the genetic resources, the sample you get, is to be used as commercially set up, or if you are actually undertaking some additional activities. And if the genetic resources you have in hand is a genetic resources as defined in the Nagoya protocol and all the national regulation. So you will still have to go through your cases on a case by case to understand and tick the different boxes to check whether or not the activity you have undertaken is falling under the scope of the regulation for compliance, whether the type of material you are using is also falling under the scope of the regulation and the national provider country regulation. So every time it's a case by case, you cannot that easily put systems in place and rules, binary rules for measuring your compliance obligation. You can filter and do a risk approach, but you cannot have a binary approach. Next, please. And also for such regulation, you also have some penalties that are set up in the regulation. For example, in the Swiss regulation, when you have a failure to comply, this could be up to 100,000 Swiss francs, when it's a negligent misinterpretation. So you started to do something, but you didn't keep the record enough time, or when you were not thinking that you were doing utilization, but you thought you were doing screening, or such tiny interpretation issues, they show some kind of flexibility on how sanctions can be led. And I think this is my last slide, Nicole, if I'm not wrong. And oh, sorry, just, well, this is not necessarily to present, but just to let you know that when you will get access to the presentation, this is where you can find the forms, the official forms, the frequently asked questions, as well as the official acts within the Federal Office for the Environment in Switzerland. Do not hesitate to go there. You have English, French, Italian, English, French, systematically, Italian sometime. So it should be easy to read it through. If you have any questions on Switzerland, we can take them apart during the Q&A, and I give the floor to Michael from SAAFFI. Thank you very much.
Okay, well, maybe just while Michael is unmuting himself and ready to present, I'll just repeat that call from Stephanie for any questions you may have. We have some time at the end of the webinar to present, to answer some of your questions. So you just need to type it in the chat box, and we'll address those at the end of the presentation. Okay, over to Michael.
Good day, everybody. The following few slides highlight what I believe to be critical aspects of the current South African legislation and regulations surrounding access and benefit sharing. Nicole, next slide, please. There are 5 pieces of legislation that need to be considered. 4 are acts and 1 is a set of regulations. These are the Constitution of 1996, the National Environmental Management Act of 1996, which is referred to as NEMA, or NEMA, N-E-M-A, the National Environmental Management Biodiversity Act of 2004, referred to as NEMBA, and then the Protection, Promotion, Development and Management of Indigenous Knowledge Act of 2019. This was a bill which we've discussed in the past, referred to as the IKS bill. And finally, the chapter 6 of the regulations covering NEMBA. This chapter is called Bioprospecting Access and Benefit Sharing. We refer to it as BABS. These regulations date back to 2008, but were somewhat amended in 2015. Nicole, next slide, please. The Department of Environment, Forestry and Fisheries, DEFF, is the custodian on both NEMA and NEMBA. Both these acts are reasonably straightforward. However, it needs to be noted that they and the BABS regulations date back to before 2010, when the Nagoya Protocol meeting took place, and before it was ratified in 2014. This means that there are differences between BABS and the Nagoya Protocol, and it is in the interpretations of BABS where the problems start. Nicole, the next slide, please. The recent enactment of the IKS bill has added to the confusion. This falls under the Department of Science and Innovation and not under DEFF. It also brings in a new concept, that of indigenous knowledge. This is defined as knowledge which has been developed within an indigenous community and has been assimilated into the cultural and social identity of that community, and includes 1. Knowledge of a functional nature, 2. Knowledge of a natural resource, and 3. Indigenous cultural expressions, such as songs or sayings. A National Indigenous Knowledge Systems Office, otherwise known as NIKSO, will be formed and will be the repository of IK, Indigenous knowledge. This office will adjudicate on questions of both TK, traditional knowledge, and IK, Indigenous knowledge, including those to do with bioprospecting and biotrade. So when IK is involved in resources that are wanted for bioprospecting and or biotrade, additional conditions can be expected. So far, no regulations under this Act have been published. Next slide, please. Back now to BABs. All utilization of IBR or IGR, that's indigenous biological resources or indigenous genetic resources in South Africa, falls under NEMBA. And an application to use any IBR or IGR must be made prior to accessing and using the resource. Permits have to be obtained for 4 distinct areas of utilization: the discovery phase, research, bioprospecting, biotrade, and research other than bioprospecting. Next slide, please. Every entity in the supply and value chain, from harvester, grower, trader, processor, and manufacturer, needs to have some form of permit to access and utilize IBR or IGR resources. It depends on the type of activity performed with or around the species. MTAs and BSAs are to be concluded at every level of transaction. That is, the material transfer agreements and the benefit sharing agreements. Considerable detail is required when completing the various templates to apply for permits. But experience has shown that what is noted on the forms is often not enough to satisfy the requirements to be granted a permit. And that is one of the really gray areas in our regulations. An applicant can be any natural or legal person residing or being registered in South Africa. Foreign entities need to have a South African partner when applying for a permit. Nicole, next slide, please. Discovery phase bioprospecting means any research on or development or application of IBR, IGR, where the nature and extent of any actual or potential commercial or industrial exploitation in relation to the project is not sufficiently clear or known to begin the process of commercialization. Biotrade means the buying and selling of milled, powdered, dried, sliced, or extract of indigenous genetic or biological resources for future commercial exploitation. It is important to note that a plant extract, for example, a tincture, an essential oil, a vegetable oil, or similar, will fall into this category. These materials are fractions of the plant and are simply removed from the plant and not altered. Bioprospecting is defined as any research or development of indigenous biological or genetic resources for commercial or industrial exploitation, and includes the systematic search, collection, or gathering of such resources, the utilization of any information regarding any traditional use by indigenous communities for R&D purposes, research, development, or modification of any traditional uses for commercial exploitation, the trading in and exporting of indigenous biological resources in order to develop and produce products such as drugs, industrial enzymes, food flavors, fragrances, cosmetics, emulsifiers, oleoresins, oddly enough, colors, extracts, and essential oils. The commercialization of the research, which covers filing of patents, market research, and so on. The next slide, please. In the case of flavors and fragrances, it is unclear whether the permit needs to be very specific as to the application or use. It would be easiest to be able to say simply fragrance compounds or flavorings. Otherwise, different permits will be needed for different types of applications, such as I want to make a guava flavor, or I want to make a fragrance that smells of the sea. Then comes the next stage in the value chain, which is unclear as far as permits are concerned. The South African requirement for a permit stops with the consumer product. To comply with the South African requirements as the provider country means that the supplier of the fragrance compound or flavoring would need a biotrade permit, and the manufacturer of the consumer product would need a bioprospecting permit covering a specific application or use. Again, it's specific, so it could be a skin cream, or it could be an ice cream, or a sweet. The situation means an exponential increase in the number of permits. Other problems are, for example, at what point in the process would these permits be required? At the sampling submission, or only when a commercial quantity is to be supplied? These problems are still under discussion with DEFF. NEMBA is currently under revision, specifically Chapter 6, and it is intended to substantially simplify and streamline the processes for BABs. That intention is from the side of industry. I'm not sure if it really applies to government. The revision is hoped to be complete in 2020, with no detailed timeline set for implementation. Next slide, please. I would now like to turn to the Buku project. We believe there's a good argument to try to achieve a form of best practice for the Buku industry in line with Articles 19 and 20 of the Nagoya Protocol. We aim to have a procedure that deals with all ABS matters at the first level of processing, after which the material becomes compliant and can pass through the total value chain without further hindrance. This will reduce all the costs incurred by the complex logistics, both for the users and for DEFF. If successful, the intention is to adopt it for other South African IBRs, and it could even become a standard best practice for use by other countries. Nicole, last slide. Thank you for your attention, and again, questions at the end as explained. Thank you very much.
Thank you. Good morning from Brazil. I excuse myself. I will switch off the camera to make it a better connections. So I'll approach the key aspects for the Brazilian ABS regulation, the ones we believe are the most important and relevant ones for the flavor and fragrance industries. Brazilian regulation is complex and there's a lot of other regulations, as I will show off. So I'll guide you through the key aspects of the regulation in place. Next slide, please. I'll try to, in a few minutes and a few slides, show you the applicable legislation in Brazil, the authorities that you have to be aware of that are relevant for the ABS regulations, the material under the scope of the Brazilian ABS law, what are the concepts of benefit sharing, and adequacy and regularization of activities in Brazil, given the regulation has some time. Next slide, please. As Maxime has pointed out, Brazil is not a party of the Nagoya Protocol, although Brazil have signed it since 2011. Nonetheless, the Nagoya Protocol is under discussion by the National Congress and it has to be ratified. But it's important to know that we have a regulation in place since 2001, and it's important to know provisional measure 2186, which refers to regularization, which I show up in a few moments. Since 2015, we have the Brazilian Biodiversity Law. It's Brazilian Law 13123, which was regulated by Decree 8772 in 2016. It's important to note that to make the regulation operational, there are complementary norms which are published, discussed, and published by designated competent authorities. There are ongoing discussions to bring clarification and procedures to operate the law. Just a few examples that I bring to you, which are important for this audience. One is the normative instruction number 3 from 2019, which specifies the species not considered genetic heritage found in situ in Brazilian territory. This is a normative instruction issued by the Ministry of Agriculture. Another important complementary norm is the technical orientation number 6, which is from 2018, applicable only for fragrances, which establishes the conditions in which a Brazilian species is considered to add value to the finished product. And I'll come to that specific technical orientation in a few moments. And a very recent one, the Ordinance 199, which it gives the path to regularization of foreign companies. The next one, please. Here I bring to you the main national authorities and relevant institutions regarding to the Brazilian biodiversity law. We have a few of them. I brought just the most important one for flavor and fragrance industry, which is the first one. I would say it's the most important one, is what we call SEGEM, is the Council for the Management of Genetic Heritage. It has a lot of functions, but I highlight two very important ones: the setting of norms and guidelines, such as two that I have mentioned previously, the Ordinance 199 and the technical guidance number 6 for fragrance. So they discuss ongoing discussions to make it able to comply with the Brazilian regulation. Also, I bring IBAMA, which is the Brazilian Institute of Environment and Renewable Resources, which the main function will be on the inspecting and investigating the actions relating to the applicable regulation and the legislation of the Brazilian biodiversity law. MAPA is also important. MAPA is the Ministry of Agriculture and Livestock and Food Supply. They are competent for the agricultural activities. And as I have mentioned previously, they issued a guideline on national species not found in situ. And also the National Fund for Benefit Sharing, which deals with funds resulting from benefit sharing. And I would say that they receive all companies' payment and to the effect of benefit sharing. One thing that I bring to you is the tool, because it's often confused with CEGEM. The tool that we have in Brazil is the CEGEM, which is the electronic system for registration made available by the Brazilian government. So CEGEM is a tool, it's an online system that we have in Brazil. CEGEM is currently in the version, what we say #1, but the version #1 was missing some functionalities, especially for the regularization of foreign companies. So the version #2 is under study. Next slide, please. Just a little brief highlights on the material and the scope of the Brazilian ABS law. Registration under the CEGEM, the electronic system, is triggered by access. And there is a definition that we bring to you in the guidance, but which can be summarized as the conduct of research and or technological development on genetic heritage or associated traditional knowledge. It's important to know that both the nature and the origin of a material condition, whether research and or technological development activities conducted, triggers access. That's very important to know. So triggers the registration and all the next steps that needs to be conducted by intermediate product companies or finished product companies. One other important aspect that I bring to you on the origin of the material is that in Brazil, there is no official list of species under the scope of the Brazilian biodiversity law. We bring to you in the guidance some reference lists, but they are not exhaustive and are constantly being updated. So in case of doubt, if an ingredient is under the Brazilian scope, consultant, professional expert should be consulted to understand, to give certainty that the material is under the scope of the Brazilian regulation. Next slide, please. On benefit sharing, there are regulations and there are norms on benefit sharing. And what leads to benefit sharing is the commercializing finished products. But we have to keep in mind that the Brazilian biodiversity ingredient has to add significant value to the finished product. And what does it mean, adding significant value? It implies that the genetic heritage or the traditional knowledge, which are defined by the law that I mentioned previously, are or were important as a determinant element for the product's functional characteristics or its market appeal. And I'll go into a very I'll go into the technical ordinance number 6 for fragrance that gives a good example of leading to adding value. It's important to know that intermediate products such as flavors and fragrance are not subject to benefit sharing. They are under the exemptions mentioned in the guidance. There are several options for benefit sharing, and ABPEC, which is the Brazilian Industry Association for Hygiene and Cosmetic Products, they have prepared this small chart that's on the screen that shows the options that are available for benefit sharing. Next slide, please. And there is the need, as there is a regulation in place since the provisional measure, and then the law 13123 from 2015. It's established, it's very important to know that all the activities mentioned in the guidance that are under the scope of the Brazilian regulation triggered by access, as I have mentioned, that were performed from June 30, 2000 until November 17, 2015 are under the need of adequacy and regularization. The guidance shows which are those conditions which are adequacy or which is regularization. But it's important to know that 2 weeks or 3 weeks ago, it was published the Ordinance 199, which establishes the procedures for regularization of foreign companies. It established the how, what to inform, who to inform, how to inform. It's important to note also that the deadline is not counting yet because there are 2 missing pieces of it. The terms of commitment, which is the first document that a company has to sign with the Brazilian government, that establishes committing to regularize the activities that were performed in this period of time. It's not available yet, but the Ministry of Environment has committed itself to make them available by the end of May 2020, by the end of this month. The second point, as I mentioned previously, SIGEN is still in its version 1, which misses some functionalities for especially for foreign companies. The SIGEN number version 2 is under evaluation. Actually, IFRA, which is the Brazilian Industry for Flavors and Fragrances Association, is participating in this evaluation, and the deadlines and the obligation deadlines will start 1 year after the second version, with all the functionalities available for foreign companies. One additional point that I think it's important to bring to you for regularization is that flavor and fragrances as intermediate products, since the law 13123, it's important to note that registration for regularization needs to have a Brazilian partnership or association with a national institution. We are working on that, and the regulation, the ordinance says, establishes which are the conditions for this association and for the national institution. The next slide, please. This is an example, as I mentioned previously, of the importance to be following the under regulations or the complementary regulations that are under ongoing discussions in Brazil. This is the technical guidance number 6, which is applicable only for fragrances, which establishes when an ingredient from the Brazilian biodiversities adds value or not to the finished products, because that triggers benefit sharing. So the path A shows when the ingredient determines the predominant olfactory family of the fragrance. so the idea here is to show when does it add value according to the law. When the ingredient, the effective family of the ingredient matches the compared to the effective family of the fragrance is determined. The ingredient, the effective family is determined of the effective family of the fragrance. Then we have to have the species registration by the fragrance house at SAAFFI, by the customer, the final product notification at SAAFFI also, and then it goes to finished product benefit sharing. But in the other way, when which is the path B, when the effective family of the ingredient does not determine the effective family of the fragrance, we still need to have the species registration by the flavor house at SAAFFI, and the flavor house has to provide the customer company with a perfumery statement saying that it does not determine. And then we have to have the final product notification by the customer SAAFFI. But it doesn't stop there, because we need to also assess if there is a market appeal to add value to that product, and then determine if there's a benefit sharing. If there's no market appeal, so there's no benefit sharing. So, and when there is market appeal, then it goes to benefit sharing. So this is an example of how the regulations works in Brazil, and the importance to be aware of all these complementary regulations that are under ongoing discussion. So I guess this is the next slide, the last slide. Thank you.
Thank you very much, Eugenia. So as a last presentation before Jocelyne gives a conclusion to all those very good presentations, I will try to wrap that up with some legal considerations surrounding the issuance of the IFRA and IOFI guidance on Nagoya and ABS legislations. Next slide, please. So what we have when we talk about the Nagoya Protocol and ABS legislations, as already mentioned by Maxime, is a real lasagna of rules and situations that companies face when trying to identify their obligations and trying to comply with those. We try to summarize that lasagna in the present slide. So you have first the international layer with the Convention on Biological Diversity, to which the Nagoya Protocol is a part. Those are international treaties. Some countries are parties to those to that convention or the protocol, but other countries are not. We have to keep in mind that as such, those international treaties do not directly create obligations or rights for companies, but they are implemented through various national legislations, and that's where things get more complex here. You first have the situation of countries which are parties to the Nagoya Protocol, and then you need to distinguish between legislations that will regulate the sourcing of the material, so some kind of access legislation, but also you may have obligations stemming from the legislation of the country where utilization occurs, so basically where R&D is conducted. But beyond those situations stemming from being parties to the Nagoya Protocol, other countries are not parties to the protocol, but may still create situations where companies should identify and comply with some obligations. First, you have countries that are not yet parties to the protocol, but may already have some ABS legislation in place. A good example of that, as was summarized by Eugenia before, is Brazil. And as another example, you also have countries which are not parties to the protocol, but and which have no ABS legislation in place, but in any case, companies that would conduct some utilization activities on a material coming from a country which is a party to the protocol would have to comply with the legislation of the country where the material is sourced. Next slide, please. So to exemplify the kind of legal challenges that a company face when we talk about Nagoya and ABS legislations, let's take the very theoretical example of an FNF manufacturer that would be based in France but would have some presence worldwide. That company would conduct some R&D activities in France to develop and produce an FNF ingredient for commercialization worldwide on a B2B basis. That company, next slide please, would therefore develop a product. It's not very important here to specify the product. Let's keep in mind it's a fragrance ingredient or a fragrance compound. But what is important is that that product has been developed through research that was conducted in the European Union here in France. That product would be composed of 3 different ingredients. The first ingredient would come from India, the second one from Brazil, and the third ingredient would come from France. Next slide, please. Yes. So as a result of that situation, the company would identify as possible sources of ABS obligations. First, obligations that would come from countries that are parties to the Nagoya Protocol. And here, first, possibly obligations coming from the fact that some materials are accessed from India and from France, as legislations where access occurs, but also obligations stemming from the fact that R&D activities are conducted in France. So the legislation of France as a country where utilization is conducted would also possibly create some obligations on the company. And beyond those countries which are parties to the protocol, one of the ingredients is coming from Brazil, and the legislation of Brazil would apply also as the legislation of a country where access occurs. As a result, next slide, thank you. As a result, in that situation, on the basis of those possible sources of obligation, there could be, and that would have to be checked on a case-by-case basis, taking into consideration the respective scope of application of each of those pieces of legislation, but possibly in a cumulative way, the company may face a variety of obligations that one could differentiate between some sort of administrative obligations related to obtaining the prior informed consent from the country of access. In the present case, from India, the company may have to obtain prior approval from the national authorities. In Brazil, as we've just heard, there could be an obligation to register access to the material, but also possibly to notify upon commercialization of the end products through a dedicated electronic system called SysGen. In France as well, some obligations may apply in terms of obtaining authorization, given the commercial intent of the activities conducted. And in addition to that, given the fact that R&D would be conducted in France, the EU regulation would apply, creating some obligation of so-called due diligence on the company, and also possibly the need to submit a declaration of due diligence. In addition to those administrative obligations, there may also well be some benefit sharing obligations on the company, depending on the exact activities conducted with the materials accessed from those different countries. So we detail here the variety of benefit sharing obligations, keeping in mind that those may be cumulative, depending on the exact situation. Next slide, please. So what this evidences is that a specific case may create a variety of obligation and may trigger the application of different legislations. This certainly creates some important legal challenges for a company. First, because of a lack of harmonization of concepts and rules at the international level. First, if you take the framework of the Nagoya Protocol itself, there is a lack of clarity of some key concepts in the Nagoya Protocol. If you take a concept such as access, which is very key to the protocol, it's not even defined. So it means that it's national legislations that will define the concept of access. Utilization, we get a rather broad definition of the terms in the Nagoya Protocol, which refers to research and development, basically, but it's very difficult to really comprehend the concept of research and development. Is it cumulative? Do you need to have research and development activities to fall in scope, or only some research activities would already trigger some ABS obligations? It's not very clear. Also, it's difficult to understand when R&D starts, when it ends. So that's the kind of difficulties that companies certainly face. If we talk about the material scope of the protocol, so we know that genetic resources and traditional knowledge are possibly to fall in scope of ABS obligations. But a concept which is of high importance to the FNF industry is the topic of derivatives. So it's not totally clear from the Nagoya Protocol whether and to what extent derivatives, which are also in some legislation called byproducts, would fall into the scope of ABS obligations. There is also the question of materials that would undergo some processing, some chemical modifications. Are they still considered as genetic resources? May they be subject to some ABS obligations? It's not easy to answer those questions. Given this lack of clarity, we see the development of very diverging interpretations between national legislations, depending on countries, and we have more than 120 applicable legislations to date. We have very various understanding of concepts such as access, utilization, sometimes very well defined. In other situations, we see very gray zones, which are not easy to solve on an everyday basis. Also, in terms of red tape, we have a wide variety of administrative procedures in terms of obtaining prior informed consent, in terms of expectations of authorities for mutually agreed terms, as well as on benefit sharing schemes and benefit sharing obligations. So this has certainly created some complexity. Plus, we need to keep in mind that beyond the Nagoya Protocol itself, some countries, as said, are not parties to the protocol, but have very well-established legislations in place, such as Brazil, with their own and very specific definition of access, some principles, procedures to follow. And in those situations, the Nagoya Protocol and the definitions that are provided and the principles provided in the protocol are of no help to the company. And finally, the situation of countries which are not parties to the protocol without ABS legislations in place, such as the USA, for example, companies there still have to comply with obligations stemming from countries that are party to the protocol, but to the Brazilian legislation as well. And this has to be kept in mind. Last slide, please. So that's where the guidance comes into play. It has been created to help company navigate through that lasagna of situations and rules. Here I would like to provide you with a legal perspective on the objectives pursued by the guidance document. First, this document tries to help companies in understanding ABS and Nagoya as a global challenge, while helping them to sort out all the rules in the lasagna, what comes from the international layer, what the national rules provide, the differences between those rules,
And the document tries to contextualize that for the F&F industry, but as a global challenge. So that's the first aim of that document. On that basis, having described what R&D is for the industry, having described some of the key legislations in place, the document also tries to provide some tools of interpretation for the companies when the company wants to develop its compliance strategy. For that, the document gives a description of the key concepts of the Nagoya Protocol and ABS legislation, such as a definition or an attempt of definition of the concept of research and development for the F&F industry, which I think is very useful and has been a very productive work. Also on some topics of importance to the industry, such as derivatives, the document gives the existing discussion on the topic, but also the document developed tools for interpretation. We understand, for example, that the concept of utilization or R&D is not always well defined in a national legislation, and it is often up to the company to develop an interpretation of the rules. And for that, the document proposes some tools for the company to develop such interpretation. This is the case on derivatives, building on some work and knowledge we gained during advocacy activities at the EU level, drafting some guidance document for the cosmetic and the F&F industry. We've been working a lot on how we could develop an operative way of having derivative fall in scope of ABS obligations. So that's something that can be used by companies now when they want to set up their compliance strategy. Keeping in mind that at the end of the day, those interpretations that are made necessary by the loopholes in a lot of existing legislations would have to be tested before national authorities, because national legislation remain the key source. It will always prevail, and it has to be, it's an important reminder, it has to be kept in mind that national legislations and the interpretation of national authorities should always be checked at the very end. Again, it remains a responsibility of individual companies to identify their ABS obligations in a concrete case. The guidance document will certainly help companies in that regard, but it will remain a business decision of companies on how to apply and how to use the interpretation tools provided by the guidance document. And in any case, and it's my role as a lawyer to remind that this guidance document should not be used as a substitute for legal advice. And again, it is for company to get used to it and to find ways to really use the very helpful information provided in that document to ensure compliance with challenging ABS obligations. I thank you very much.
Yes, thank you, Matthias, and thank you to all the presenters. We wanted to have a short conclusion to close the webinar. So we're already at the end of the webinar, and I guess that by now you are a little bit confused if you are feeling like me with all the different approaches and the global perspective inherent to biodiversity. What we can probably all agree on is that we do support as individuals, as company, the biodiversity question, the fair and equitable sharing of benefits. That, of course. Having said that, biodiversity is a global aspect, which is quite fragmented from a regulatory point of view. And this means that there is no one solution fits all. That's not possible. We have to a couple of keywords that we heard during the webinar are really awareness, due diligence, traceability, and record keeping. And maybe we can go to next slide, please. Yeah. We might need to adapt our system and processes internally if we want to put those obligations in place. Just as a little exercise, and to recap on all what was said, which was quite dense. Let's take a colleague is coming to me mentioning, okay, I just take a sample of a plant somewhere. I want to use it. Is it okay? So basically, that's not enough. I will have to ask some questions. And the basics question that I will have to know is the date of acquisition, the country of origin, the type of material, and the contact detail of the suppliers. This can be probably done through a questionnaire that is maybe available already in your company, and that could be updated, integrating these basics of due diligence on Nagoya. Then, basically, based on the country of the provider country, we will have to check whether there is a regulation in place or not. If there is a regulation in place, and this can be done through either the national focal points or this ABS clearinghouse, which is supposed to collect all the information. It's not always completely up to date, but there are quite a lot of information there. If there is a regulation in place, then you will have to dig into or maybe I will have as a regulatory person to dig into the details and to understand whether the sample is considered as a genetic resource, and whether the way I got it is accessed. And if it's the case, then I will need to assess whether the way I'm using it is considered as utilization. Is it, and utilization usually is linked to R&D activities. And R&D activities is really, accumulating knowledge, new insight on the material. So basically, except, if we keep exception aside, like Brazil, the formulation of a fragrance should not be considered as R&D activities. And then if you are ticking all the boxes, you might have obligations, and you might ensure that there is a peak, or maybe to put in place a MAT, so really to have all the legal framework to ensure the fair and equitable sharing of benefits. And as mentioned by Stephanie, you will have to document everything and keep records of everything. So you also have maybe to adapt your system to be sure that you can track back all this analysis, this assessment that you did on your sample. Okay, that's then a 6-step example of due diligence that might inspire you. So the very last slide, I believe. Next slide. Our future. So in a couple of words, I'm not going to repeat myself because I already talked about that, but we are going to remain a quite active task force in the future. We will continue to focus on priority countries, and of course India is one of the priority countries. We got a question on it, so Maxime will detail that. And we will continue as well to nurture our IFRA and IOFI network and the partnerships, because as it is a global topic, we need to ensure that we have the right people in the right place. So that's my last word, and I have a very, very last slide, which is, yes, if you have additional questions, if you have additional ideas for the task force, like I absolutely need this to be able to implement Nagoya for the company, please let us know. And you have 2 contact points, Maxime and Matthias. So please don't hesitate to contact them. Thank you very much for attending this webinar. I hope that it was interesting to you. And David will now organize the end of the webinar with the question slot.
Thank you, Jocelyne. Thank you, everybody. Okay, so let's just have, before we go to the Q&A, a short quiz for you. So I just change my slide there. Okay, so we have a quiz. You can vote on the webinar application. You just have to click the screen. The questions should be fairly simple if you've paid attention over the last hour and a half. So let's go. So first question is, what does ABS stand for? And you see the options on the screen: access and bonus shareholders, access and benefit sharing, acquisition and bonus shareholders, or amour, bien-être et santé. You can vote now. Okay, close that one. Okay, I should be able to share the, oh, there we go. So pretty much everyone got it right. It was, in fact, the answer was access and benefit sharing. Okay, so for the poll number 2, ABS principles define, is it A, fair sharing of benefits from use of genetic resources? Is it B, dividend mechanisms for shareholders? C, responsible sourcing? Or D, R&D activities? And I think most people have had a chance to vote now. So I'll close that, and yeah. You're good at this. It was indeed A. Okay, poll question 3. Let's launch this one. So ensuring compliance requires A, traceability, awareness and due diligence, B, complexity, reputational risk and climate, C, love, fun and games, if only, D, expertise, diplomacy and working in silo. And again, it was indeed A. Question 4, let's go for a question on particular countries and their obligations. So are there benefit sharing obligations in Switzerland? So just choose one here. Yes, no, it's free, or no, but voluntary agreements are welcome. Okay, just give it a few more seconds. We'll close that one and share the results. So most of you did get it right, actually. The answer is indeed C. It's no, but voluntary agreements are in place. Okay, question 5 is, now this question, you can have multiple answers in this question. So all of those that apply in this case, under the South African ABS regulations, for which of the following activities does one require a permit? A, discovery phase research, B, biotrade, C, bioprospecting, D, research other than bioprospecting, or E, manufacturing license. As you'll have a few more clicks to do this time than normal, so just give you a few seconds. Let's close that one up. Sorry if you didn't get a chance to vote there. In fact, the answer is everything except E. So it's A, B, C, and D. So well done to everyone who got those. Let's move on to the penultimate question. So again, it's just one answer here. In Brazil, who is responsible for signing a benefit agreement with the authorities? Is it the research institutes, the intermediary supplier, the brand owner, or the farmer? Again, a bit of a split here in the answers, but more than half of you got this right. It is indeed the brand owner. The last question. Excuse me. The last question is, again, choose all of those that apply. What are the key steps to start integrating ABS in a company's processes? Is it to collect sample information, collect regulatory information, to do a legal assessment, to keep detailed records, or to implement applicable obligations? Let's close that and share this. And it is, in fact, all of those things. So plenty of things to do. That's all we can really say on that. Okay, so at this point, we'll move on to the Q&A section now. And maybe if I just if we can move on to the Q&A, I'll just organize my screen. So we have had about 10 or 12 questions, and I will I'll pose these to the people who I think are probably best placed to answer them as we go through, and others can jump in as necessary. The first question is a kind of organizational question from Naila Raga. It says, I see today India is not in the agenda for discussion. Will this be in a future one? So, Maxime.
Thank you, David. So indeed, India has been rightfully mentioned as a key country for our industry. I would first invite you to check and consult the annex of the guidance document dealing with India. We have worked with the law firm on spot to develop this chapter, so it's very up to date. And now I think that the ABS situation in India continue to evolve. We are still clarifying some concepts, but also trying to get the best interpretation from the guidelines issued by the Indian authorities. So as soon as we get the answer, this will be firstly implemented within the Indian chapter. And on this, maybe it's a good opportunity to remind to everybody that the guidance, it's a living document. So it will evolve with the different regulation here and there, and maybe also the Nagoya protocol, we never know. So you can expect some updates sometimes, and on India for sure. So finally, if we feel at some point that ABS in India would require a webinar, we'll do even a specific one on India, like we did for Brazil last year. But for the moment, I don't think it's on the program. But please consult the Indian chapter first, and I think that you will have already a lot of answers. Thank you.
Okay, thank you, Maxime. We had a couple of questions on compliance issues from Sophie Regazzoni. Does a fragrance company developing a new fragrance ingredients subject to the Nagoya Protocol or ABS regulations need to inform its customers? So I think Stephanie is probably best placed to answer that.
Yeah, thank you. So with regard to that question, there is no legal obligation usually set up in the national regulations to show compliance to your client. However, and Thomas will build on, but when there is a material transfer agreement or where there is a specific clause in your benefit sharing agreement that might create a certain obligation. However, it's important to understand as well that your client might need to show their own compliance to the authorities when they put a product in the market. So they might need from you a statement saying that you are compliant. It's usually best practice and as well a transparency approach as to share your compliance level with your client. Thomas, please build on what I've said.
I agree with you, Stephanie. I think that the Nagoya protocol itself does not provide for such obligation. Then in theory, it will depend on national legislation, but that is, we cannot give such a detailed answer. But in any case, it could well be that mutually agreed terms could provide for such obligation. So that would be the source where to verify if such obligation exists.
Okay, Thomas, while you're there, we had another question from Sophie, which was, would it be possible to get summaries of obligations depending on the company's categories, so ingredients, compounds, finished products, etc.? But I understand this is quite difficult given that there's a complex lasagna, as you say, of legislation.
Yes, unfortunately, it will be very difficult given the variety and the nature of the obligations applicable to really classify those in that way. Maybe someone could add on that if they have another view. But I would see that as a very, very challenging exercise.
Yeah, I think that's probably the case, that there's is a very complex subject with lots of different legislations. So yeah. But
what we can sorry, Stephanie speaking. What we can add to it here is the different fact sheets that we have prepared for the guidance, for example, where we try to really explain the type of activities and material scope and utilization scope. So in any case, it will be based on the national regulations. So we cannot summarize or regroup and categorize a regulation that easily. But definitely, when you look into the fact sheets, we try to really highlight for you to have a quick view of which kind of utilization, which kind of scope the national regulation is talking about.
Great. We had quite a few questions on Brazil. So Eugenia, you can see if you can answer briefly some of these. On Brazil, can the list from IFRA, this is a list of ingredients derived from Brazilian biodiversity, can they be added to the guidance, or can you provide the web link so we can find it online? And there was another question, which was if fragrances were formerly exempted but are now in the scope of new regulation 199/2020. Eugenia, I don't know if you have any comments on that.
Okay, David, thank you. On the first one, on the list, just a little bit of background. I have mentioned during my presentation the technical guidance number 6, which establishes the way that the ingredient, the Brazilian biodiversity ingredient, adds value or not to the fragrance and then to the finished product. So what IFRA has done was a reference list of the most used ingredients from the Brazilian biodiversity, and with all the member companies from IFRA, try to agree on the olfactory family of those ingredients. So that's what we have done. What it's important to note It's a reference list that we have, so we are able to comply with the regulation. I mean, if it's needed, if we agree to share it, it's there, but we are committed to be reviewing it as needed.
Okay, thank you, Eugenia. So another question, we have one on South Africa, if Michael's available. So only IBR, IGR indigenous to South Africa species are regulated. So those species that are indigenous to South Africa. Is there a list of these species?
There we go. Yes, that's a very good question. The list is not complete. There are various places one can go to and ask if the product is indigenous to South Africa or not. But eventually it will all come down to that NICSO establishment, to that office that they're going to establish. But it's a good question, and I've asked, in fact, myself a number of times whether a particular ingredient, particular IBR is indigenous, and the answer was vague. So I'm sorry, I can't give you a very definite answer either.
Okay. Okay. There is one on essential oils and in particular in India. So what is the Nagoya's position and also local rules on the use of essential oils derived from citrus, such as lemon oil originated from India, since they have been widely used for a long time? That's from Luciana Silva. I think, Stephanie, you might have an answer to that.
Yeah, I can help and provide some ideas. So here we are looking specifically to India. So when we have the citrus species that is cultivated from the Indian territory, in that perspective, looking at the Indian regulations that you can have access toward through the fact sheet later on, what is important to distinguish is the commercialization with the trade when you source the species to make an extraction, and when you do research and development activities. For the commercialization and the trade aspect of it, the regulation would apply except on a list of exempted species that is considered as normally traded commodities and TAC list, which is published in the National Biodiversity Board, which is a national competent authority. That list is exempting for trading to get any permit needs and obligation for such species. However, if you undertake R&D on that citrus species coming from India, you would fall under the scope of the NBA regulations, the Biodiversity Act, and you would require prior approval from the National Biodiversity, National Competent Authority. So definitely depends on your activity. And if it's trading, you could use this exempted list of species. If it's R&D, you need to apply the obligations for whatever kind of species that you're taking from India.
Okay.
And if I add on that, sorry, David, Thomas speaking. If I may add on that, in the specific example provided, we are talking about the lemon oil, and in the Indian legislation, the situation of byproducts will be even a little different, since there would be a need for the user, I think, to demonstrate that the oil as such would be traded as a commodity, so as a matter of common practice, and which would not be the case. Like, so it's the exemption would not apply as a principle, but there may be a need for the user to demonstrate that the application would apply, the exemption would apply.
Okay, thank you, Thomas, and thank you to all of our panelists. I realize that we are now at 34 minutes past the hour, so we've overstepped our mark by 4 minutes. We have had more questions. We've taken note of all of these questions and we'll attempt to answer them in another format. So it might be in a future webinar or in a written format. But can I just say to everybody who's taken part, not least to our presenters who've done such a good job, but also to the 250 or more attendees at the webinar, thank you very much for your time. It's a really complex topic, it's a very interesting topic, and it's one I'm sure we'll come back to. The guidance document is available on the IFRA-IOFI SharePoint. If you don't have access or you need access, then please contact Matthias or Maxime and they should be able to handle your request. So just leaves me to say thank you very much for joining. You will get a copy of the recording in the coming days and more information. Thank you once again and enjoy the rest of the day. Goodbye.